My name is Anel. I'm a professor of law at the Northwest University. I am also the South African Research Chair in Cities, Law and Environmental Sustainability. Today, the fast rate of urbanization in Africa and the impacts of global climate change on the continent's cities affect livelihoods, economies, and development trajectories. And research on the extent of this is proliferating as economists, geographers, planners, climate scientists, environmentalists, and financiers turn to Africa in studies that have for long, perhaps too long, been fixated on the global north. Collectively, these experts are interested in questions of population growth, urban and climate migration, land use planning, resource exploitation, water scarcity, flooding and pollution, loss of biodiversity, energy, mobility, impacts on agriculture and investment. This is done against the backdrop of a canvas speaking of poverty, marginalization, colonization, and the desperate need for long-term just transitions on our continent. Intriguing for me is the relationship between the wave of post-colonial constitutional law reform and how this may assist in forcing government and private sector action towards climate responsiveness in Africa. On our continent, there is a relative paucity of research and low levels of reporting on climate change cases. Websites that aggregate climate cases indicate that only a handful have been finalized on the continent, mostly in South Africa and in Kenya. Of these, they have primarily involved administrative requirements, in particular, a failure to consider climate change impacts when approving coal-fired power plants. I am, however, of the view that the health and environmental rights in the constitutions of many African countries provide a very steady legal basis where governments or emitting companies, which states are supposed to regulate, fail to take the necessary climate action. In South Africa, for example, people have the right to an environment that is not detrimental to human health or well-being, and this right should be respected by all. This right and the failure to uphold it was recently used to win a case, the so-called deadly air case, brought against the environmental authorities in South Africa. Despite the might of constitutional environmental rights, the challenge lies in addressing climate change in a manner that does not prevent people in Africa to prosper and develop. Many constitutional environmental rights actually refer to sustainable development, a balancing act which is often quite tricky, considering, for example, how fossil fuel dependent Africa remains. Considering the upsurge in climate litigation across the world, especially in the United States and in Europe, it seems as if it's going to be a matter of time before climate change cases are brought before courts in African countries. I cannot disagree with those who claim that climate litigation is a very valuable tool to force domestic action on climate change. However, I am wary of the fact that the absence of the necessary financial means and limited legal standing prevent millions of African people from lodging climate cases against their authorities or others. My message, therefore, is that the paucity of climate change cases in Africa should not be read to suggest that climate change is not yet serious enough an issue on the continent. It is very, very serious, as was already made very clear at the recently held 2022 Africa Climate Week in Gabon. Millions of African people are already affected by floods, severe droughts, biodiversity decline and deforestation, energy poverty, and changing weather patterns, mixing up decades of agricultural practices. These are direct impacts. There are, of course, also indirect health and economic impacts. And I trust that the combination of these impacts and the accumulation of vulnerabilities will prominently feature in the conference rooms in Egypt. Governments in Africa have to act. They have to be ambitious in their governance efforts. And they should be enabled to act upon their duties in terms of the Paris Climate Agreement and the United Nations Sustainable Development Goals. Despite the beautifully crafted environmental rights we have, there is no time to wait for climate cases and courts for action. Much of my own research focuses on cities in Africa, and I can perhaps conclude by saying that the global environmental crisis and urbanization makes for the perfect storm in many African countries. The convergence of these trends put tremendous stress on urban infrastructure, the provision of adequate housing, water and sanitation services, roads, and the ability of authorities to maintain environmental health standards. A recent research project of ours in a selection of Southern African countries has, however, shown that cities remain rather slow in adopting local climate action plans, policies, or bylaws, and it is my hope that this will fast change in the very near future. Local legal and policy reform would, however, need the support of global city networks, funders committed to just and well-financed climate action, as well as civil society experts, researchers, and other partners. It is hoped that this matter will also make it to solution-oriented discussion forums at the upcoming COP27 in Egypt. Perhaps as a concluding positive message for the African continent and people living in Africa. It is true that the global environmental crisis is upon us and that it is serious and that we should never downplay. However, I think that there is vast opportunity for us as an African continent to capitalize on the wealth of the human and natural resources that we have, and to do so wisely in order to ensure that the future on this continent remains green and bright, not only for ourselves, but certainly for our children and their children.